Ladies and gentlemen, I welcome all to my channel. Today we shall discuss about the various ingredients required to constitute an offence punishable under Section 138 of the Negotiable Instruments Act. Or otherwise, if a check bouncing case is filed as against you, what are all the defenses? What are all the grounds of defenses? Are all discussed in this video. In this video, I am going to discuss about 17 grounds of defense with supporting judgments which accused can use for to defend your case and to come out of that check bouncing case. So regarding the check bouncing case, it is mentioned as an offence under Section 138 of the Negotiable Instruments Act. As far as the sections is concerned, it stipulates various aspects, various ingredients. So if all the ingredients are covered, duly complied, then it will amount to an offence. Assuming for a moment, we will call a person as a man if he has all the essential requirement. Supposing a person has hand, who does not have the, is not a living person. Will you call them as a man? We will not call him as a man. It's a body, like that we will call. So like that, if any one ingredient is not there, any one of the elements stipulated under Section 138 of the Negotiable Instrument Act is absent, then it will not amount to an offence, and we can plead that it is not an offence because one of that element is not properly complied. So as far as 138 of the Negotiable Instrument Act is concerned, it was specifying that it specifies that the check has to be issued for the discharge of the whole or a part of the debt or liability, and it is to be presented in a particular drawing bank, and it should have been bounced due to insufficient funds, and again within 3 months, and the check ought to have been presented within a period of 3 months, or immediately after the check is bounced, a demand notice or dishonor notice should be sent to the dryer to pay the check amount. That notice has to be sent within 30 days from the date of the dishonor, and again the case should be filed within 30 days from the date of that failure to pay the amount. So if all these elements, all these requirements were complied, then it amounts to an offence punishable under Section 138 of the Negotiable Instruments Act. If suppose any one of the element is missing, supposing after the check is bounced, the complainant did not issue any notice, or the complainant did not file a case within the time limit, or if the check is not issued for a debt or liability, then you can take it as a defense, and you can defend your case, and you can come out of the case. So now let us discuss 17 grounds which are available now, and we'll also discuss those grounds one by one, and along with the supporting judgments in favor of that ground. The first ground is that check issued as a security. Supposing the check is issued only as a security, and initially such type of check issued as a security cannot be if is presented for collection and is dishonored, then it was declared as that there as a 138 offence will not attract for those types of transaction. Now the court's decision varied, and now the as per present situation, the check issued as a security must have been presented for collection if a check is issued as a security, the liability must exist at the time of presentation to attract section 138. Like what the latest judgment reported in 2016 10 SCC 6458 is reported. So if a check is issued as a security, then at the time of presentation of that check, there must be a liability. Assuming for a moment you are asking for giving a check for the construction of a house, and we are intended to deliver this check for the after the completion of the construction work. Now the construction work is not completed, it was in the halfway, and the builder presented a check and makes the collection means, then at the time of presenting the check, the liability did not exist, the liability to pay, because the work is not completed. So underground you can make it as a defense. We can make this as a ground for defense. The second ground is no legally enforceable debt. Suppose there is no legally enforceable debt. Assuming for a moment you are not liable to pay any amount to any person, but you have issued a check, or otherwise suppose you gave the check to do an illegal act. So then the liability to pay, there is no legally enforceable debt. So in such circumstances, if a check is issued for a not illegal purposes, or for for a purpose which is not legally enforceable, then in that case that will not be section 138 will not attract for the discount of such type of checks. In judgment in the case 2008-4 SCC 54, it was reported that the presumption under section 138 is rebutable, and the accused can demonstrate the absence of legal liability. As far as section 139 is concerned, it gives a presumption in favor of the holder. So as far as the law is concerned, for all the checks, the court will presume that the check has been issued for the discharge of any particular debt or liability. So it is a presumption, but it is a refutable presumption. Suppose the accused is able to prove that the check is not issued for any particular debt or liability, or if you have particularly prove that there is no such debt or liability between the complainant and accused, then the presumption shall be refuted. Then the burden will be shifted to the complainant to prove that he has to prove that the accused is really liable for any such transaction, and there is a debt really exists in between the complainant and the accused. Like what the burden will be shifted to the complainant. So the third ground is that for the second ground, 2007-6 SCC 528, the legally enforceable debt, or the court held that the legally enforceable debt or liability must exist at the time of presentation. Then third ground is check issued under coercion or fraud. Supposing a check was obtained by fraud or coercion, then the section 138 will not attract. In case number 2019-4 SCC 197, the court held that the accused can rebut the presumption by proving the check was obtained by fraudulently or under coercion. So the fourth ground is material alteration. So suppose the contents of the check was altered without the consent of the drawer, then section 138 of offence 138 will not attract. In judgment 2007-2 SCC 258, the court held that the material alteration without drawer's consent invalidates the check, like what the court has observed. Then the fifth ground is disputed signature. Suppose the signature is disputed by the accused, and assuming that the signature was forged. So then the section 138 will not attract. In judgment 2009-2 SEC 513, the court held that the accused can disprove liability by proving the signature on the check does not belong to them. So if you are able to prove that the signature is not yours, then that will be a good ground to come out of the case. Then sixth ground is check presented beyond validity period. As per the section 138, the check must be presented within the date specified within the validity period. So if it has to be presented within 3 months from the date of issue or from the date mentioned in the check. Suppose the check was presented after the 3 months validity period, then the section 138 will not attract. So in judgment 1998-6 SEC 514, the court held that the check must be presented within its validity period, namely 3 months from the issuance. The seventh ground is that insufficient notice. So as per section the 138, it stipulates that once a check is issued dishonored, the demand notice has to be sent. So if the demand notice is not sent, or if it is sent, it is not sent in time, then it will the section 138 will not attract. So 199-7 SEC 5110 case, the court held that the proper service of legal notice is mandatory for a valid cause of action under section 138. So in another case, 2009-1 SEC 720, the court held that the failure to comply with notice requirements can invalidate the complaint. So the notice has to be sent within the validity, within the 15 days from the date of dishonor, and it has to be served on the accused, otherwise the 138 offense will not attract. Then eighth ground is non-compliance with time limits. So the complaint should be filed within 1 month from the date of the cause of action. So as far as the law is concerned, if the check is bounced, within 15 days, demand notice has to be sent, and the other side has to be the accused should be asked to make payment within 15 days from the receipt of this notice. So once if he failed to, I think the demand notice has to be sent within 1 month from the date of after the amendment. Within 1 month, the demand notice has to be sent within 1 month from the date of dishonor, and then in the demand notice you have to give us to 15 days time limit. And if the 15 days time limit is not properly, if the payment is not made within that 15 days, then the case should be filed 138 for an offense under section 138 of the Negotiable Instruments Act within 1 month from the date of that failure. So from after the 15 days expiry, the case should be filed within 1 month. So if the case is not filed within that time limit, then it will also, then in that case also the 138 Negotiable Instrument will not attract. And the ninth ground is absence of funds or insufficiency. Supposing there is a fund, and if the check is bounced by due to stop payment, suppose that my own person sent a material, and the material that it has, suppose your person purchases a fridge, it is not working, it is not proper condition, so immediately issues a stop notice. So the check is bounced with the stop notice. In that case, the 138 section 138 offense will not attract. So it is in 2006 SEC page number 39. The court said that the stop payment due to bona fide dispute may not constitute an offense under section 138. Then the 10th ground is check issued without consideration. Supposing a check was issued as a gift to married people and it is bounced, so there cannot be there is no consideration. So when it is freely given, so when there is no consideration, so in that case, such type of if a check is dishonored for that reason, section 138 offense complaint cannot be filed. In case number 2010 11 SEC 441, while the court held that while section 139 presumes consideration, the accused can rebut this presumption, like what the court has given its observation. Then lack of jurisdiction. So as far as the case is concerned, it has to be filed in the court where in the place where the check was dishonored. In 2014 9 SEC 129, the court held that the jurisdiction lies where the check was dishonored and not where it is issued. So the criminal case has to be filed where the check has dishonored. Then in 12th ground is a check not presented at drawee bank. So if a check is issued to a particular bank, it has to be presented to that particular bank. If it is not presented to a particular bank for collection, then there cannot be an offence. In 2010-12 SEC 166, the court has held that if the check is not presented at the drawee bank, no cause of action arises under section 138, like what this court has observed in this case. Then the 13th ground is where check lost or misused. Supposing the lost check is misused or the check is stolen and it is misused, then in that case also the check bouncing case will not come. So in 2007-12 SEC 714, the court held that if the check was lost or stolen or misused, section 138 cannot be applied. And the 14th ground is that the settlement between the parties. Supposing the check bouncing amount or any mutual settlement is arrived between the parties, then in that case also check bouncing case will not come. In 2018 1 SEC 560, the court has held that the settlement between the parties can lead to quashing of the proceedings under section 138. So if the matter is settled amicably, in spite of that the case is not closed, then a party can approach the High Court to quash the complaint on the ground of settlement of the dispute. The dispute on quantum of liability. Suppose there is a dispute between the complainant and accused with respect to quantum of liability. Assuming that the check was a person obtained a loan of 10 lakhs and issued a security check 10 lakhs. And in the meantime, he paid a part amount of 4 lakhs to the financier, and the financier suppressed the payment and presented a check, the 10 lakhs checks, and filed a case. Means then the quantum of amount, quantum of liability is here in this case is if it is varied, then in that case it will weaken the section the complaint. So if a check is issued, security check is issued for 10 lakhs and the liability is only for 6 lakhs, then that check cannot be presented for collection. Then premature presentation of check. So suppose check is issued, a check presented for collection prior to the liability period, then in that case also offence will not attract. In judgment 2014-12 SEC 539, the court held that the check presented before liability becomes due does not attract section 138. So supposing if you have to make a payment only next year, and the check security check presented was collected 1 year before itself. So in that case, it will be treated as a premature presentation of check. So in that ground also we can make it as a ground for defense. Then the 17th ground is check bounced due to technical reasons. Supposing there's a date is mismatched or there's a spelling mistake or corrections, and if the check is returned due to the technical reason, then section 138 of the negotiable instrument will not attract. So these are all the 17 grounds, legal grounds, which is available to an accused to defend his case and to come out of the case. In addition to that, if you are pleading for arguing the case, it is always better to make an alternative plea when you are with reference to the punishment. Supposing after submitting the argument and the court comes to conclusion that you are an accused or offence is made out, then you can also make an alternative plea with respect to the quantum of punishment or quantum of fine. So you can explain the court your difficulties, your physical inability or your financial inability or your health issues or other. Supposing you are a breadwinner and if you are put in jail, your entire family will be put in trouble and they will also lose their life. You can also point out all the genuine reasons to the court, so that the court will also consider those things and give a minimum punishment as much as possible as per the conscience of the court. So these are all the things I want to share through this video. I will come with another topic, suppose how to handle your check bouncing case. So suppose check bouncing cases are there, what are the ways to come out of that case? That we will discuss in the next video. Ladies and gentlemen, we have two channels, Razyak Law Tube and is a English channel, Razyak Sattam Ariyum is a Tamil channel. You can watch my two channels and enrich your legal knowledge. In addition to that, if you have any specific doubts or clarification or consultation, you may contact this cell number. If time so permits, I will give you necessary online consultation, or you can also I will give you necessary legal advice as per my availability and time. Thank you. Goodbye. Razia Kali.